Assalamualaikum warahmatullahi wabarakatuh. My name is Amirul Haziq bin Kamiran, 056789.
Hi guys, my name is Amira Binti Sapian and my metric number is 056798.
Hi, my name is Izzat Fakri bin Halimi. My metric number is 056818.
Hi, my name is Farahanis Namilah binti Muhammad Aziran. My metric number is 056819.
Assalamualaikum and hi, my name is Ahmad Nabil bin Muhammad Asri. My metric number is 057016.
Group 14 will be presenting the topic of an introduction to prismatic approach by judges in regards of fundamental liberties within federal constitution. Malaysian constitution has been endured for more than a half century. According to Article 4 of the constitution, federal constitution is considered as the supreme law of the land. Being the fundamental law of the country, the constitution has been referenced to the other laws, especially on state administration and governance-related matters. Recent development witnesses various constitutional issues are brought up to center stage, especially the issues that are related to fundamental rights provisions. In addressing the current development, a comprehensive and wide understanding on the heritage foundation of the Constitution is crucial. This is the foundation to all sectors to understand not only the black letter but the spirit of all the constitutional provisions. In addition, it benefits the judiciary in interpreting the constitutions. Judicial interpretation can be defined as a process by which the courts interpret the meaning of a statutory provision for the purpose of applying it to a certain situation. In the simplest term, it is the way how the judge interpret the law. In Malaysia, the story of Malaysian judiciary is inseparable from the nation's constitutional politic, in which the theme of politics determine the judicial institution rise, fall, and subsequent struggle of the judicial institution towards constitutional restoration. However, this video will not discuss the judicial interpretation between the context of judicial institution and politics, but rather emphasize on the prismatic approach applied by the judges in regards of fundamental liberties within our federal constitution. There are several modes of the Malaysian constitution interpretation, but the courts usually emphasize on the exercising within its own four walls approach. The judges under this principle refuse to engage with sources from international law principle, as the courts view it as irrelevant to the Malaysian constitution. The leading case of Government of Kelantan and Government of the Federation of Malaya began the four walls approach. The court in this case said that the constitution must be interpreted within its own four walls and not taking into consideration the analogies created by other countries such as United States of America and Great Britain. Besides, the Malaysian courts also exercise the strict literalism and formalism approach in interpreting the federal constitution, especially when dealing with constitutional rights guarantees. For example, the federal court has been formalist and legalist in interpreting a statute that related with the right to equality in the case of Dana Harta Urus and Kekatong. In this case, a statute provided that the courts could not make any order that would stay, restrain, or affect any action taken by Dana Harta as the nation's asset management company. The Court of Appeal had held that this provision violated the constitutional rights of equal protection of the law, and thus it should receive a broad, liberal, and purposive construction. The Federal Court overruled the decision of the Court of Appeal and adopted a formalistic approach toward the right of equality. However, the Malaysian courts have departed from the strict literalism toward a more generous and purposive approach in its judicial attitudes, which is prismatic approach. Datuk Gopal Sri Ram has illustrated prismatic approach as a condition. When light passes through a prism, it reveals its constituent colors. This approach was exercised by the courts in the cases involving fundamental liberties provisions such as Article 5 and Article 10. Consider the landmark case of Sivarasa Rasiah and Badan Peguam Malaysia. The Federal Court held that restriction on the Article 10 right to freedom of association must be read restrictively and that the fundamental rights provision must be generously interpreted. The court in its view said that it is the duty of a court to adopt prismatic approach when interpreting fundamental rights provided under Part 2 of the Constitution.
Completing this assignment, we are using library research of qualitative method where we get information and data from two sources. The first is primary sources. In this assignment, we use our federal constitution as our primary source. There are certain provisions that we look into in discussing about our topic. The first is Article 5 and the second one is the Article 10 of Federal Constitution. Apart from that, we also refer to the cases that have been mentioned in the question to study and discuss in our assignment. We also refer to the other cases that we might consider as related to our assignment in answering the issue arose. For the secondary sources, we use some books and journals to get some additional information regarding the prismatic approach that have been used by the judges to decide the case regarding the freedom that have been mentioned in our federal constitution.
The prismatic approach can be seen in Lee Kuan Yew against public prosecutor case. Based on the fact, the appellant has been charged for the offence of drug trafficking of 420 grams of cannabis, which constitute an offence under Section 39B, Clause 1, Clause A of Dangerous Drug Act 1952, punishable with death. The High Court held that the appellant is liable. In the High Court, the judges were satisfied that the prosecution had made out the prima facie and therefore disallowed any submission from the defence counsel. Upon appeal, the Court of Appeal affirmed the decision made by the High Court. The appellant later appeals to the Federal Court, claiming that his right of fair trial, provided under Article 5 Clause 1 of the Federal Constitution, has been violated. The Federal Court held that the conviction was quashed. The Federal Court in their judgment has prismatically interpreted Article 5 Clause 1 of the Federal Constitution and in light of Article 8 Clause 1, which relates to the concept of life and personal liberty. Thus, in interpreting the meaning of life, the court believed that it does not merely mean the animal existence. However, it does include the right of livelihood and the quality of life. The appellant's right to make a submission should not be deprived from them. However, it is their right to choose whether to waive it or to use it. Therefore, the Federal Court, upon interpreting the meaning of fundamental liberties by virtue of Article 5 Clause 1 of the Federal Constitution, found out that the appellant did not have a fair trial and his constitutional right has been violated. Gopal Sri Ramjas has firstly introduced the prismatic approach in this case. In his judgment, he stated that the Constitution is a sui generis document that applies the principles of interpretation. Therefore, the provisions need to be generously interpreted and not in their literal sense. He also argued that it is the responsibility of the court to adopt a prismatic approach to the interpretation of fundamental rights. It is based on the phrase of when light passes through a prism, it reveals its constituent colors, which means the prismatic approach shall reveal the right provided under Part 2 of the Federal Constitution. The prismatic approach has given life in the meaning of Article 5 Clause 1 of the Federal Constitution to abstract concepts such as the meaning of life and personal liberty. The prismatic approach laid down by Gopal Sri Ramjas has been supported by few cases. One of it is Datuk Menteri Othman bin Baginda and another against Datuk Ombi Syed Alwi bin Syed Idrus. Raja Azlan Shah has stated that there are two important points that need to be considered in interpreting a constitution. Firstly, the judicial precedent plays a lesser role than in matters of ordinary statutory interpretation. They also quoted Lord Wilberforce, whereby in his judgment, he stated that a constitution is a legal instrument given rise, among other things, to individual rights capable of enforcement in a court of law. Respect must be paid to the language which has been used and to the traditions and usage which have given meaning to that language. It is quite consistent with this and with the recognition and rules of interpretation may apply. To take as a point of departure for the process of interpretation, a recognition of the character and origin of the instrument, and to be guided by the principle of giving full recognition and effect of those fundamental rights and freedoms. It is also supported in a Hong Kong case whereby, in the case of Leung Kwok Hung and the Hong Kong Special Administrative Region, Lee Chief Judge has stated that in his judgment, it is well established in our jurisprudence that the court must give such a fundamental right a generous interpretation so as to give individuals its full measure. On the other hand, restriction on such fundamental right must be narrowly interpreted. Plainly, the burden is on the government to justify any restriction. This approach to constitutional review involving fundamental right, which has been adopted by the court, is consistent with that followed in many jurisdictions. Needless to say, in a society governed by the rule of law, the courts must be vigilant in the protection of fundamental rights and must rigorously examine any restriction that may be placed on them. Gopal Siram Judge also has laid down other principles which relates to the prismatic approach. The fundamental rights must be read generously and by way of prismatic. However, it does not apply when interpreting provisos. The court must first look into the provisos which limits or restrict any fundamental rights provided under Part 2 of the Federal Constitution before applying the prismatic approach. It is supported by the case of Prispinder and the Queen, whereby Lord Nicholas of Birkenhead and Lord Hope of Craighead, in their dissenting view, stated that the courts are the guardian of the constitutional rights. Therefore, it is the court's duty to interpret the provision related to fundamental rights to ensure that the citizens' constitutional rights are guaranteed. However, in interpreting provisos, it shall be by way of restrictive, hence it shall be interpreted strictly.
Hi, I'm Haziq. In other aspects, judges' implication of the prismatic approach also give more concern by interpreting Article 10 of the Federal Constitution. By looking at Article 10 of Federal Constitution, provides the freedom of speech, assembly, and association to all citizens, which this article focuses on the fundamental liberties. Limitations upon freedom also are mentioned in this article. In Malaysia, courts have been very formal and legalist in interpreting the Federal Constitution. Judges prefer to engage a strict legalism way or approaches which is very detailed, looking into law and does not need further analysis once a clear meaning has been established towards constitutional interpretation. Refer to the case of Sivarasa Rasya, where the appellant is one of the participants who joined a peaceful walk. Then, he was arrested by the respondent after he ignored the order by police to disperse. After being acquitted and discharged, the appellant claimed for wrongful arrest, wrongful detention, and malicious prosecution. From the evidence presented, the appellant was able to prove that the case he suffered damages as a consequence. The federal court appeared not to employ legalism strictly but to be more generous and purposive, which looks into the intention of the article itself while interpreting. It was held that restriction on the Article 10 right to freedom of association had to be both reasonable and proportionate. It was found that the restrictions practiced by the respondent were not reasonable within the meaning of Article 10. We can see that this outcome was a result after court endorsed a prismatic approach to the interpretation of the provisions of the Constitution, in particular of the fundamental liberties guaranteed under the Part 2 must be generously interpreted. Next, we go to the case of Nik Nazmi bin Nik Ahmad, where the appellant organized an indoor assembly, but then he was arrested by police officers in charge because he failed to comply with Section 91 and Section 95 of the Peaceful Assembly Act 2012. Both sections provides that failure to notify the police at least 10 days before the date of assembly, criminal sanctions can be imposed onto organizers of the public assemblies. It was held in the Court of Appeal, where both sections was an unreasonable restriction on the constitutionally guaranteed right of citizens to assemble peacefully. In other words, the restriction was inconsistent with public orders and fundamental liberties, which not in line with Article 10. Court also held that Article 10 must be read in conformity with the general jurisprudence relating to reasonableness and proportionality. It was constitutionally wrong to criminalize freedom of assembly, which had merely breached such requirements, which is 10 days to notice. From the case of Siva Rasa and Nik Nazmi, we can see that judges in the court had been involved in more restrictive and formalist approaches, since the approach comes to commencement, which begins with the departure of appellate court's decision. Here, restrictive and formalist approaches means that court had reached the decision by focusing on the arrangement of the words rather than the implication of the words contained in the law, which is interpreting the Article 10 within the scope of reasonableness and proportionality. While looking at the case of Public Prosecutor and Uniswaran, the situation is similar to Nik Nazmi's case, where Uniswaran Ramaraj had failed to give notice 10 days before he organized a rally, which is required in the ruling provision of the Peaceful Assembly Act 2012. Therefore, High Court was relying on the Court of Appeal's earlier decision in Nik Nazmi's case as judicial precedent. However, the prosecution's appeal requested the Federal Court to look at the issue of citing jurisdictional grounds as in the subject matter of its constitutionality. So, Federal Court in this case had passed this matter to the Court of Appeal to be decided under the court, as the Court of Appeal had delivered the decision in the Nik Nazmi's case. Departure from the earlier decision in Nik Nazmi's case, so in 2015, Court of Appeal upheld a new decision stating that the Peaceful Assembly Act is valid and did not violate Article 10 of the Constitution. Court refused to follow the Federal Court's approach in Siva Rasa's case, which had established that restrictions on freedom to assembly must be reasonable within the Constitution. Court also declared that the legislative competency of Parliament is the correct approach that needs to be looked at, not merely on the reasonableness of the constitutionally itself. The non-inclusion of the word reasonable in Article 10 gives the meaning that the reasonableness is only valid pertaining to the result of judgment that is reasonable to the Parliament, not the courts. Therefore, to allow court restoring the word reasonable will be regarded as taking over the power of Parliament, as the drafting of the Constitution is firmly a task under the framers who draft the Constitution. In this situation, from formalist approach, we can see that the court had returned to the strict legalism approach and did not comment about the quality of the law. Here, strict legalism approach means, as mentioned earlier, it is another method to interpret that does not need further analysis once a clear meaning has been established. Judges should also avoid drawing inferences from any previous statutes or constitution and instead focus on exactly what is written. I know that all of you must be so boring listening to my voice, but please, I have one last case to be presented. Plus, you cannot stop me or you cannot ask any question because this is a voice recording. So, let's go. For the last case is Public Prosecutor and Azmi Sharom. Azmi Sharom had challenged the constitutionality of 1984 Sedition Act after he was being charged under the Act for stating his opinion on the part of legality in the Perak constitutional crisis. He stated that the Act was not valid because it was not enacted by Parliament, and Article 10 of FC prescribes that it has the exclusive authority to enact laws restricting the right to freedom of speech. Based on Section 41A and 41B of Sedition Act, it is provided that it is directed and effective towards any act, word or publication that may contain seditious elements or tendencies. Upon prosecution's appeal, it was held in the Federal Court, where Sedition Act was still consistent with Article 10 that includes the right of freedom of expression. Arifin Zakaria CJ was in opinion that it is not duty of court to determine whether the restriction imposed under the provided legislature pursuant to Article 10 is reasonable or otherwise. However, the court had accepted the approaches of proportionality that were laid down in Sivarasa's case in determining the validity of law. The definition of an act within the seditious tendency was proportionate with the restrictions on fundamental rights imposed under the legislation, which it was still in line with the Constitution. The approaches of proportionality also is considered to be a more firm and rigid standard of view than reasonableness upon judicial approaches.
For the conclusion of prismatic approach in our presentation is that the prismatic approach, which is another limb of judicial interpretation, asserted as a guideline to preserve the nature of the provision in the Constitution, specifically in interpreting the provision relating to fundamental liberties. This new approach, invented by Gopal Sri Ramjaj in the Lee Kuan Yew case, is a turning point to our society and public needs, as it saved many lives from being defenseless and vulnerable or falsely executed. This approach also seems related to concept of constitutionalism, where the concept of constitutionalism limiting the power of the politician not to override the power to legislate the law. But in this case, the judge's widened interpretation will limit the power conferred to the person who has locus standi to use it as a weapon, or the benefit of widened interpretation is to enlarge the scope to be preserved from being executed of unjustifiable action recklessly from irresponsible person. In addition to that matter, this kind of approach varies the manner of the court approach in interpreting the provision under the Federal Constitution, owing to the fact that the wording in the constitutional provision concerning to the fundamental liberties is too broad to be understandable in a single read, which is the real problem at first. Therefore, with the court assistance to provide specific meaning and functioning will be so much helpful in this issue. Thank you. That's all from us.